We have seen some recent examples of the diversity of law at work with the Karen Reid trial and most recently the Rust trial. Alec Baldwin's trial was dismissed with prejudice mid-proceedings on Friday by Judge Mary Summer. Judge Summer agreed with the defence's motion after holding an evidentiary hearing regarding the allegation that prosecution had suppressed exculpatory evidence. Judge Summer left the bench and personally assessed the evidence herself, leaving no stone unturned after his defence team discovered the Brady violation. Alec's legal team included US attorneys Luke Nikos and Alex Spiros, whose expertise and prowess exposed the evidentiary omission that led to the dismissal. The evidentiary hearing took several hours and included the prosecutor, Kerry Morrissey, calling multiple witnesses to the stand, including herself. Ultimately, Judge Mary Summer ruled that the court could not right the wrong and that a dismissal with prejudice was the only fair option on the table. Now, just imagine, hypothetically, just for a moment, indulge this concept. What if the judge making the ruling on Alec Baldwin's motion to dismiss wasn't Judge Summers, but Judge Beverly Cannone? Given that it appeared throughout the Karen Reid trial that her bias was towards the state, would the outcome have been the same? Now let's go a step further and imagine that the prosecutor was one Joseph Mansfield, someone who makes Kerry Morrissey look like the pure-driven snow. Joseph Mansfield, a renowned prosecutor in Monroe County, Florida, has had somewhat of a colourful career. And without going into too much detail, albeit to say that his professional career may not be as exemplary as it should be. Now, imagine that you are the one on trial and you have no legal support whatsoever, no backup, no advice, no trial tactics, a limited knowledge of the practice and process of the law, the knowledge that you obtained from trial by error in an unfamiliar arena with everything on the line. No Jackson and no Yannetti. Well, welcome to Franklin Tyrone Tucker's world. He was wrongfully accused in 2017 of the murder of Matthew Bonnet in the Treehouse in Key West. Pro Se Defendant Ty has been fighting an uphill battle of innocence since then. His choice to go pro se was to garnish enough attention to expose the deep-seated corruption in the Florida Keys. His battle to date has included, but by no means limited to, his first trial judge, Judge Mark Jones, recusing himself after reluctantly declaring a mistrial in January of this year. The subsequent reallocation of a fresh judge, one with a new set of eyes, a newly appointed military protege of the former judge, with a point to prove and an axe to grind. A state attorney's office hell-bent on keeping him quiet. You see, Ty started his own YouTube channel after his mistrial and began posting all of the evidence of his innocence that was not permitted during the trial, along with the receipts of all the shady dealings he had to contend with. He was out on bond, awaiting trial, and unfortunately was late to a random urine screening test. The opportunity was seized and an immediate bench warrant was issued for his arrest with a whopping $3.1 million bond. He was actually on his way to surrender himself when he was arrested at the Oregon airport, the state opining that he was a flight risk despite his one-way ticket to Florida. He's now sitting in jail awaiting retrial on the 6th of September 2024. Now, the State Attorney's Office have actually rehired a prosecutor who's been suspended not once, but twice by the Florida Bar. Now, you may not have liked Lally, but Lally worked through 40 witnesses before the lead investigator took the stand. But no such lead investigator has ever been called so far in Ty Tucker's case. The prosecutor was suspended for nearly 2.5 years in total. Not only did she misrepresent to the court and opposing counsel her knowledge and possession of pertinent statements, she didn't include them as evidence. Sound familiar? She was also involved in the coercion and manipulation of planted informants within the jail and appearing in matters that were clearly a conflict of interest. At the initial trial, the state issued a protection order, which Ty has sought to amend, given that the current order is preventing him from contacting a vital state witness, Todd O'Quinn. He's vital in that he's the only witness remaining that can exonerate him. The state had arranged a plea deal for a co-defendant, John Travis Johnson, on the grounds that he testify against Ty at the first trial. He has since recanted this testimony, but the damage has been done. The only other witness was one of the victims and the resident of the treehouse, Paula Belmont, who testified on Ty's behalf but has since passed away. With his divorce not finalised, he is no longer eligible for a public defender. He has no money to hire an attorney, and he has to face a prosecutorial team that are less than honest. And so he is left to fight this battle on his own, a battle of deep-seated injustice and corruption, with no protesters outside the courtroom, with no defence fund, with no crash daddies waiting in the wings, and no FBI investigation to swoop in and clean up the mess. Battling the legal process and procedures, the deadlines, the unknown quantities of an evolving trial, the expectations of a militant judge, and the unknown strategies of a prosecutorial team that have proven their inability to participate in a fair and trustworthy manner. This is no even playing field. This is a minefield of collusion. It is a battle for his life, and his hands are tied. How do we right this wrong, Mary Summer? An innocent man could potentially go to jail for the rest of his life. Is his life less important than Karen Reid's? Will anyone help turn the wheels of justice for Franklin Tyrone Tucker?